Chapter 21. Murder. Section 405. Definition, Koch's description, requisites. Murder is the killing of a human being without justification or excuse and with malice aforethought, express or implied. According to Sir Edward Koch, murder is committed when a person of sound memory and discretion unlawfully kills any reasonable creature in being, and under the King's peace, with malice aforethought, either express or implied. To constitute murder, the following conditions are essential. 1. The slayer must be of sound mind and discretion. 2. The victim must be a reasonable creature in being, as distinguished from an unborn child. 3. The slayer, at the time of the homicide, must entertain malice aforethought. 4. The victim must die within a year and a day after the act. Section 406. Mental capacity of the slayer. The slayer, as heretofore stated, must be of sound mind and discretion at the time the act is committed. If his mind is diseased, so that he is incapable of distinguishing between right and wrong as to the act committed, or, according to some decisions, though he is capable of distinguishing between right and wrong as to that act, but, owing to want of power of control, he is incapable of eschewing it, he lacks capacity to commit murder, or, if his mind is so immature that he lacks capacity to entertain legal malice, he cannot be guilty of murder. Section 407. Victim must be a human being. It is not murder to terminate the life of an unborn child. It is Koch's view that if a woman be quick with child, and by a potion or otherwise killeth it in her womb, or if a man beat her, whereby the child dieth in her body, and she is delivered of a dead child, this is a great misprision, and no murder. And as said by Bishop, a child within its mother's womb is not a being on whom a felonious homicide can be committed, it must be born. Section 408. Independent circulation. To be fully born, a child must have independent circulation. It is possible, however, for a child to have a potential independence prior to its actual independence. An example of this is where a child is severed from its dead mother by the caesarean operation and survives. But even in this case, an actual independence is essential to constitute the child a living human being. Section 409. Independent respiration. Must a child have breathed independently of its mother to render it a living human being? Upon this question the authorities are not harmonious. It is Casper's view that in fora the term life must be regarded as perfectly synonymous with respiration. Life means respiration. Not to have breathed is not to have lived. Bishop's opinion is that neither need the child have breathed, if otherwise it had life and an independent circulation, and according to Justice Park, a child must be actually wholly in the world in a living state to be the subject of a charge of murder, but if it has been wholly born, and is alive, it is not essential that it should have breathed at the time it was killed, as many children are born alive, and yet do not breathe for some time after their birth. The latter view is in accord with the weight of modern authority. Section 410. Severance of the umbilical cord. Can a child be fully born before the severance of the umbilical cord? Upon this question, also, the authorities are not harmonious. Bishop answers it in the affirmative. According to the better view, however, as well as the weight of modern authority, a child is not fully born, and therefore not the subject of homicide, until the umbilical cord has been severed. Section 411. Effect of premature birth. The fact that the child is born prematurely, that is, before the full period of gestation has elapsed, is immaterial. Hence, where a person unlawfully causes the premature delivery of a woman, and the child is born alive but subsequently succumbs owing to the fact of its premature birth, the person who thus causes its premature birth is guilty of murder. If the child be born alive, and dieth of the potion, battery, or other cause, this is murder. Section 412. Malice aforethought, express and implied. The distinguishing feature between murder and manslaughter is malice aforethought. Its presence is essential to enact the crime murder. In its ordinary sense, the term malice means hatred or ill will. In the crime of murder, however, it has a technical meaning. In this sense it includes wicked and corrupt motives, as well as hatred or ill will. Malice is either express or implied. To constitute express malice there must be an actual intent to kill. Express malice is when one, with a sedate, deliberate mind and formed design, doth kill another, which formed design is evidenced by external circumstances discovering that inward intention, as lying in wait, antecedent menaces, former grudges and concerted schemes. Implied malice, on the other hand, is malice which is inferred from conduct on the part of the slayer, which indicates an abandoned state of mind, fatally bent on mischief, and which is equivalent in the eye of the law to an actual intent to kill. Such malice may emanate from conduct which manifests cruelty of disposition and recklessness of consequences. The law infers guilty intention from reckless conduct, and where the recklessness is of such a character as to justify this inference, it is the same as if the accused had deliberately intended the act committed. Section 413. Actual intent to kill not essential. To constitute a homicide murder, an actual intent to kill is not essential. A sane person is presumed to have intended the natural and probable consequences of his voluntary acts. Hence, when he voluntarily does an act which has a direct tendency to destroy another's life, the necessary conclusion is that he intended to so destroy such person's life. Section 414. Malice presumed from the act. Upon principle, a legal presumption should not arise from the mere fact of homicide. As said by Judge Cooley, as the majority of the homicides are not, in fact, malicious, but occur through misadventure, or under circumstances which would reduce the offense to manslaughter, a legal presumption of malice seems inconsistent with the general doctrines of the criminal law, as well as with humanity. Best takes an opposite view. Although the law never presumes guilt or fraud in the first instance, yet it is held, that where a homicide has once been proved, the law will presume that it was done maliciously, and casts on the party accused the onus of proving either his complete justification or excuse, or such palliating circumstances as may reduce the offence to manslaughter. This view is in accord with Foster's and Blackstone's, and is also supported by the great weight of authority. But, upon principle, as heretofore stated, no legal presumption of malice should arise from the mere fact of homicide. On the other hand, however, the surrounding circumstances may give rise to a presumption of facts. Section 415. Malice presumed from the use of a deadly weapon. When a person, without justification, excuse or extenuating circumstances, commits homicide with a deadly weapon, malice is always presumed. A deadly weapon is one likely to produce death or great bodily injury. Some instruments are deadly weapons per se. As a general rule, when a homicide is committed by striking with the fists, or kicking with the feet, and the slayer has no actual intent to kill, or cause serious bodily harm, the necessary malice to render the offense murder is not implied. On the other hand, when the circumstances surrounding a homicide manifest an abandoned and wicked heart, malice is implied. It may be implied from setting fire to a building in which there are persons. Section 416. Willful omission to perform a legal duty. When death is caused by the negligent act of another, the homicide, ordinarily, is manslaughter. But when it is caused by a willful neglect to perform a legal duty, it is murder. Thus, if a switchman of a railroad company is grossly negligent in failing to perform his duty in adjusting the tracks, thereby causing death, the homicide is manslaughter, but if his will concurred in his negligence, he is guilty of murder. Section 417. Deliberation and premeditation. Deliberation and premeditation are not essential elements of common law murder. No specific time must necessarily elapse between the intent to kill and the overt act to render the homicide murder. It is sufficient if the malicious intention precedes and accompanies the overt act. Section 418. Deliberation and premeditation. Statutory degrees of murder. At common law, murder is not divided into degrees. In many states, however, there are statutes which divide murder into degrees. In most states it is divided into 2 degrees, but in a few states it is divided into 3 degrees. Pennsylvania was the first state to divide murder into degrees. The statute was passed March 31, 1860, and provided that all murder which should be perpetrated by means of poison, or by lying in wait, or by any other kind of willful, deliberate, and premeditated killing, on which should be committed in the perpetration of, or attempt to perpetrate, any arson, rape, robbery, or burglary, should be deemed murder of the first degree, and all other kinds of murder should be deemed murder of the second degree. The statutes of the various states in which murder is divided into degrees are not entirely harmonious, but in most of them murder in the first degree consists in homicide in which there is actual intent to kill coupled with premeditation or deliberation, or in homicide which is committed, though unintentionally, in the perpetration of certain felonies, such as rape, robbery, burglary, or arson. Section 419. Meaning of terms premeditation and deliberation. The terms premeditation and deliberation, as used in these statutes, are not synonymous. The former implies merely previous contrivance or formed design, while the latter implies reflection, however brief, upon the act before committing it, fixed and determined purpose, as distinguished from sudden impulse. Thus, a homicide committed on a sudden impulse may be premeditated, owing to the intent to kill, and at the same time not deliberate. An act coexistent with and inseparable from a sudden impulse, although premeditated, could not be deemed deliberate, as when under a sudden and great provocation one instantly, although intentionally, kills another. But the statute is not satisfied unless the intention was deliberated upon. If the impulse is followed by reflection, that is deliberation. Hesitation, open, may imply deliberation, so may threats against another, and selection of means with which to perpetrate the deed. If, therefore, the killing is not the instant effect of impulse, if there is hesitation or doubt to be overcome, a choice made as the result of thought, however short the struggle between the intention and the act, it is sufficient to characterize the crime as deliberate and premeditated murder. The deliberation and premeditation required by the statute are not upon the intent, but upon the killing. It is deliberation and premeditation enough to form the intent to kill, and not upon the intent after it has been formed. An intent distinctly formed, even for a moment before it is carried into act, is enough. Section 420. Murder in the second degree. In those states in which murder is divided into two degrees, all murder which falls short of being murder in the first degree is, of course, murder in the second degree. And what was murder at common law is still murder under the statutes which divide it into degrees. In other words, these statutes have not changed the scope of murder as it existed at common law. Section 421. Suicide. At common law, suicide, or self-murder, was a crime punishable by forfeiture of the felon's estate and interment in the highway with a stake driven through his body. These penalties, however, have been abolished, where one person persuades another to kill himself. The former is guilty of murder. If present when the act is committed, he is a principal in the second degree, and if absent, he is an accessory before the fact. Where a person in attempting to commit suicide accidentally kills another, he is guilty of felonious homicide. But whether the offense is murder or manslaughter is a question upon which the courts express doubt. Where two persons enter into a compact to kill themselves together and the means employed causes the death of only one of them, the survivor is guilty of murder. At common law, an attempt to commit suicide is a misdemeanor. In some states, however, including Massachusetts, it is not punishable. Section 422. Proof of the corpus delicti. To convict a person of felonious homicide, the law requires clear proof of the corpus delicti. The corpus delicti includes two things: 1. The fact of death, and 2. The fact that it was effected by means of human agency. Whether the corpus delicti can be established solely by circumstantial evidence or not is a question upon which the authorities are not agreed. All agree, however, that the evidence upon this point must be clear and convincing to sustain a conviction.